Setz is the president of Spinal CSF Leak Foundation. He's going to make the introduction of our next speaker.
I have the rare opportunity as a surgeon to introduce a lawyer. But, you know, I just met Attorney Shea briefly, and he seems to be such a delightful gentleman that I wish he'd been a surgeon. He is a JD PhD and graduate of Loyola Law School and is licensed to practice in both California and the state of Washington. He's a board-certified expert in Social Security disability advocacy, excuse me, certified by the National Board of Trial Advocacy. He practiced exclusively in Social Security and SSI law. Attorney Shea has represented claimants at all levels of adjudication, including initial applications, administrative hearings, and also actions filed in U.S. District Court. He's a member of the Los Angeles County Bar Association's Social Security section and currently serves as the secretary and has previously served as the 2000 to 2001 chairperson. Please welcome Attorney Shea.
Appreciate it. Hello, folks. As the doctor just mentioned, I make my living representing people applying for Social Security disability benefits. It's a big subject, and I got awfully hungry looking at some of those slides with food on them, so I don't want to run over in the lunch hour, or at least if I do, not very much. So let's hop right to it. Whoops. Yeah, the first thing, a couple of factoids that struck me as I was doing some reading to prepare this talk. Most importantly, the World Health Organization indicates migraine headaches are the 8th leading cause of disability in the world. That really did surprise me. And down there at the bottom, it's been estimated that 157 million work days a year are lost in this country alone due to people who suffer from migraine headaches. So, can they be the basis of a disability? Yes, they can. But before you start thinking about Social Security, you need to know that the term disability jumps around a lot. If you're looking at state disability programs, different definition entirely than Social Security's, or workers' comp, or long-term disability insurance from a private insurance carrier. Everybody has this kind of slippery fish definition of what is disability. So here is Social Security's. And I probably should have put quotes around it because it comes straight from the Code of Federal Regulations. To Social Security, disability is defined as the inability to do any substantial gainful activity by reason of any medically determinable physical or mental impairment, which can be expected to result in death, or which has lasted or can be expected to last for a continuous period of 12 months. A lot of legal talk with 3 significant components. Number 1, there has to be a medically determinable impairment, which is the cause of disability. I can't tell you how many of my clients, at one point or another in our encounters, has looked at me and said, "Who would hire me?" Which is a legitimate concern to everybody except a disability analyst for Social Security. To meet this definition, the question isn't, are you employable? The question is, if you were employed, would some aspect of your medical condition prevent you from doing the job? no matter how hard you feel you need to try. Okay? Second important component, the medically determinable impairment must prevent any substantial gainful activity. What is that? Well, that's Social Security's term for work. The medical problem has to prevent work. Third, the medical impairment must last or be expected to last 12 months or result in death. That's what they call the duration requirement. So if you're 11 months, 29 days, 23 hours, and 59 minutes, you get better. Tough luck. Didn't last the duration requirement, then that's a bright line test. Okay, what's a medically determinable impairment? I'm going to skip through this pretty quickly. I saw the word fibromyalgia on a previous slide, so I'm going to assume you people have heard of that. In 1994, fibromyalgia was not thought to be a medically determinable impairment. And I sat across from orthopedists in hearing rooms who said, well, it mostly affects females and it's a kind of a hysteria, and it's not really a medical impairment. You can't see it under a microscope. By the way, I'm sure all of you are aware of the fact that our word hysterical comes from the Greek word hysteros, which means womb. And I'm pretty sure that doctor had an odd perspective on females when he talked about fibromyalgia, because it does affect many more females than males. But the real point here is now they do consider it a medically determinable impairment. Why the change? Well, largely thanks to the American College of Rheumatology. They came up with diagnostic criteria which exclude some people with the symptoms and include others in the diagnosis. A medically determinable impairment doesn't have to be seen under a microscope, but it does have to be something diagnosable and for which people get treatment. You see a lot of talk in the regulations about medical signs and laboratory findings and things like that. Diagnosable is what counts. Now, what about that business about preventing any substantial gainful activity? Is that literally true? And what is substantial gainful activity? Well, it's two words, not one, because it has two components. The activity has to be substantial, meaning the kind of thing you normally do to earn money, and it has to be gainful. Now, when I talk about this concept to people, I like to pause here because courts really do get into questions about this. For example, if you are a volunteer worker for Heal the Bay right here in Santa Monica, and you go there 8 hours a day, 5 days a week, and you do everything that an administrative assistant would do, are you engaging in substantial gainful activity? And the courts have said no. It has to be something for which you get paid. It is substantial activity, but not gainful. Flip the coin. What about activity like drug dealing? Is that substantial gainful activity? You make money doing it. Do courts really? Yes, they do. This one went all the way up to the Supreme Court, and the court said, yes, indeedy, drug dealers are engaging in substantial gainful activity. They have to make appointments. They have to carry inventory. They have to tout the advantages of their product. Substantial gainful activity. There's a fascinating case about a lady who was, the medical term for it is nuttier than a fruitcake. She was a complete psychotic. No question disabled. They get to the hearing, and it turns out she had supported herself through prostitution a number of times. Now, is a prostitute engaging? The court said, hey, in California, prostitution is illegal. In Nevada, it's not. It's a job. Therefore, a prostitute is engaging in substantial gainful activity. But never fear. A prostitute who works for a pimp is not engaging in substantial gainful activity because she gives all the money to the pimp. She doesn't keep any of it. Do courts get into that stuff? Yes, they do. The citations are right there if you care to read them. They're kind of fun. What about any substantial gainful activity? Don't leave this room thinking a person has to be huddled in a dark room, shivering and completely incapacitated to qualify for Social Security disability benefits. You don't. In fact, if you can't do the work you've done in the past, and you are over age 50, and you happen to be limited because of your medical problems to some form of sit-down work only, and it has to be unskilled, even though there are jillions of unskilled sedentary jobs out there, that person qualifies for disability. If you're over 55 and you can't do your past work, and you're limited because of your medical problems to either sit-down work or what Social Security calls light work, that's work you gotta do standing and walking, but not much lifting. Think bank teller or movie theater usher. If you're over 55 and you're limited to that kind of work, you still get disability benefits. You still qualify. You do not have to be an invalid. Now, what programs are administered? What can you qualify for? The reality is that there are dozens. Programs for widows, programs for disabled widows, programs for disabled adult children, programs for divorced spouses. That's Social Security term. I didn't make it up. These programs all differ from one another by non-medical standards. The medical standard is always the same. If you meet the medical definition of disability for one program, you meet it for all programs. And let's talk a little bit about what you get if you are qualified. Well, number one, you get a monthly benefit. You see two programs up here, disability insurance benefits and SSI. Those are two different disability programs. They differ by non-medical standards. The disability insurance benefit program, which is by far the largest, requires that you have a work history. And that work history has to be both long and recent. Long meaning long enough to qualify you for a retirement benefit. Recent meaning at the point you become disabled, you have to have worked at least 5 of the previous 10 years. No financial qualification. You can be Donald Trump and qualify for disability insurance benefits. It doesn't matter how much money you have. And some people, disability attorneys I know, think they could probably win his case in a heartbeat. But SSI, it doesn't care if you have a work history, but it does care how much money you have. You have to have limited resources and very limited income. What do you get? You get a monthly benefit. Again, that may differ depending on which program you qualify under. You get some form of back pay. With disability insurance benefits, that back pay can go back as far as 1 year before the application. And you also get some form of medical insurance. With disability insurance benefits, you get Medicare. With SSI, you get Medicaid, or what we here in California call Medi-Cal. How do you file? Go to a Social Security office. Take a number. They give them out now on strips of paper that are about 4 feet long because that's usually, you got a lot of waiting to do. They give you a packet of forms that tell you to bring them back. You can file a disability application online, but not an SSI application or applications for some other programs. If you use the online program, it's pretty user-friendly. It lets you back out of the program and go get other information, then come back and pick up where you left off. How long does it take? Social Security says 4 to 6 months, and in my experience, that's pretty accurate. Social Security is going to gather up your medical records. You may be required to go to an exam, and you'll probably get a few forms to fill out about what you do during the day. And then you'll get a letter. You never get to interact with the decision maker. And the letter says, yes, we think you're disabled, or no, we don't. What process do they use to decide? This is actually worth reading about, but it's not going to affect your behavior if you're thinking of applying, so check out the slide online later. I'm hungry, just like you. What are our chances of approval? Unfortunately, not good. Social Security only approves 1 application out of every 3 they get. And what do you do if you're denied? Well, I'm a lawyer, so I say appeal. And there are 3 steps in the appeal process for a Social Security application. The first is what we call a request for reconsideration. That's kind of like when your teenage son comes up and says, can I use the car keys? And you say no, and then he says again, please, can I use the car keys? The outcome doesn't change much, but the Social Security will reconsider, get more medical records, send you another letter. And if you're denied on reconsideration, you get to file a request for a hearing, which is conducted by a federally tenured administrative law judge. That means he has a lifetime appointment, and he will review the case independently. If he turns you down, you have 1 more step in the appeal process, which is to go to the Appeals Council. Appeals Council's in Washington, and that's the only place you can appeal from a judge's denial. So they got a big backlog. If they affirm the judge, your only remaining avenue of appeal is in the federal courts. How long do the processes take, and what are the chances of success? Here comes the real bad news. If you're one of those unlucky 2 out of 3 that gets denied after 4 to 6 months, you file a request for reconsideration. It's going to take another 4 to 6 months. And about 12% of reconsiderations are approved, which means you have an 88% denial rate. That's huge. Okay, so we file a request for hearing. Certainly a judge will do justice for us, won't they? Well, from the date you file that request for hearing till the date you're sitting in front of the judge can be 18 to 24 months. I just read an article the other day from Social Security that says the average backlog at a Social Security hearing office is now something like 680 days per case. That's over 2 years. What are the chances once you get there? 46% of cases that ALJs see, they approve. And remember, those people have been turned down. What, twice? So persistence is a virtue. Now, I should also say that in the year 2010, the approval rate at ALJ hearings was 62%. The drop to 45 is very significant. And the reasons why are complex, but fundamentally it's because these are not good times for the disabled. People in 2010 thought people like me who represented disabled people were, really generous, good-hearted, wonderful people. Now they look at you and say, you represent those people who are trying to jive the system. There's been a shift, and that shift has impacted how judges and other people view cases. Appeals counsel review, remarkably slender chances of getting anything out of that. 1% get approved. 13% get another hearing before the same judge, by the way, that turned the person down the first time. And it takes 24 months for the appeals counsel to do something. So, between the time you apply and the time you hear from the appeals counsel could be 5 years. It's not an easy process. It's brutally difficult. Let's talk about migraine headache sufferers and what you should do. The first thing you need to do, good. I thought I was running over. There's a little clock here. Oh my God. First thing you should do is realize what the problem is with a pain case, as people like me call it. Nobody knows how much pain is being suffered except the person suffering it. And that creates a problem of proof. Now, as far as migraine headaches are concerned, what you're going to have to prove is the frequency, the duration, and the severity of the migraine headache. How do you prove that? Well, a couple of reminders. Number one, in the process of determining whether you are eligible, Social Security is going to look at your daily activities and how badly they've been impacted. Social Security is going to consider the frequency and severity and duration of that migraine headache problem. Social Security is going to look at what the employment chances are. And Social Security is going to review your medical evidence. Remember, there are some jobs out there that are not physically demanding. Hotel lobby security guard, the physical demands are pretty much equivalent to being able to watch television. So cognition deficits, attention deficits, focus and concentration deficits become important in migraine headache pain cases. And it may be a good idea not only to voice those concerns when you get the opportunity, usually in front of an administrative law judge, but also to get your doctor to start writing stuff down about cognitive effects in his chart notes. And most important, I can't emphasize this in a migraine headache pain case, keep a log. It's a pretty impressive piece of evidence when you're in a hearing room and the judge says, well, how long have you been suffering migraines? And the person pulls out this yellowed notepad and starts flipping pages and says, well, the first entry in my log was 4.5 years ago. That kind of documentation is impressive. It's evidence. And if it corresponds to the chart notes, between April and November last year, I was getting 3 migraines a week. And you look at the chart notes and lots of doctor's visits in that period of time, that's a lot of good evidence. Now, medical records are the big deal. That's where the big footprints lie. So what should they contain? Well, certainly diagnostic methods your doctors used. Any kind of special testing or anything like that they did, even if the test came up negative, usually you want to see something reflected in the medical records. Also imaging scans like MRIs and CTs. Now we all know that they may come up empty. They may show nothing at all. Does that mean you don't have migraine headaches? No, it doesn't mean that at all. But it does mean that your doctor who administered those tests took your complaints very seriously. MRIs and CT scans and things like that are not cheap. And doctors don't order them unless they feel that there's a legitimate reason for doing so. Medications, very important. I've represented people who take medications. Usually their medication regime bounces around a lot. The doctors will say, well, this one, okay, it doesn't work, to try this one. It's important to report side effects of medications. Some medications control the pain but create horrible side effects. Others don't control the pain at all. And still others are aimed primarily at a side effect of the disorder itself, like nausea or double vision or something like that. So medications and getting a good, thorough record in your medical chart about medications and their side effects and the frequency with which they are changed, again, an important thing to see. Also, chart notes need to span a period of time. Remember, there is a duration requirement. And you want to include chart notes, or at least medical records, from medical professionals that you may have only seen once, like maybe an emergency room doctor, things like that. And finally, down here at the bottom, what's called a longitudinal report. Longitudinal. Judges in Social Security hearings love this word. Well, the longitudinal treatment record doesn't really show. And what they mean is they like to see a pretty steady period of treatment. If there are big treatment gaps, it looks a little bit like the pain isn't maybe as bad as you say it is, or wasn't for a significant period of time. Also, it's important that you follow prescribed therapies. Follow your doctor's orders. There are good reasons for refusing certain kinds of treatments, but you can bet you will be asked to explain what your reasons are if you're not following prescribed therapies. So, that's the advice I would have to give you. I'm so hungry that, gosh. I tell you what, let's go back a little bit. What does Social Security think, actually, when they ask themselves whether a person is disabled? Now, if I can make the back button work. The process of determining disability. You might obviously understand that you don't just get to walk into the court and say, I'm disabled, and they take your word for it. It's often said you can walk into a courtroom and make allegations about the moon being made out of green cheese. But you don't get a finding that it's made out of green cheese until you offer evidence. What is the process? Well, first, Social Security asks, are you working? If you are, since the definition says disability precludes work, they turn your claim down. The second thing they ask is, well, what kind of medical impairments do you have? Could they possibly be the basis of a disability? I have a severely infected hangnail. Sorry. That's not the basis of a disability. They look at your records there to some extent. They want to see a medically determinable impairment, and they want to see something that at least to some minimal extent could impact your ability to work. If so, they go on to ask other questions. If not, they turn you down. The third step in the evaluation asks whether you have a medical condition that can be presumed disabling. most people don't win at this step. The conditions that are presumptively disabling, you might think of blindness or quadrophilia or psychotic mental disorders or something like that. Most people aren't that sick. Or if they are, they get approved on initial lap, the 1 in 3. If you don't get awarded at that step, they ask 2 more questions. And these are the questions that settle most cases. Number 1, does the person have the functional capacity to return to their past work? And by past work, they mean any job you've done in the last 15 years. Now, to answer that question, they have to come up with an idea of what your functional capacity is. That is the crucial, where the rubber meets the road part of every disability case, proving functional limitations. And here's where it comes into play. Let's say your past work was that of a movie theater usher, and you have such a bad back that you can't stand and walk for more than a few minutes at a time. They take that functional restriction, can't stand and walk, match it up with the requirements of the job. Movie theater ushers got to walk around. And if they don't jive, you can't do that job. So at step 4, they look at your past work and your functional capacity. At step 5, if you can't go back to your past work, they ask, well, what other jobs might be available? And they do the same thing. They match up your functional capacity with those other jobs. So in my last slide a few moments ago, when I said your doctor is probably going to need to produce a longitudinal report about your condition, an important element of that report should be how your symptoms impact your ability to function. It doesn't help if you got the head of neurology at Cedars-Sinai writing a long, impassioned letter about you have this terrible migraine headache problem, if that doctor doesn't also say something functional about you. I think this problem would cause this person to miss work at least 3 or 4 days a month. That's a functional restriction. And when you get to that hearing, and remember, if you apply, chances are your case is going to end up at a hearing because of the high denial rates. There's going to be a vocational witness at that hearing, an expert. I like to call them tarantulas. And that expert is going to be asked, would a worker who is going to be absent from work more than 3 days a month be able to sustain work 5 days a week, 8 hours a day, according to the expectations of employers? And the vocational expert will say no. That person's disabled. There's no job that's compatible with that work restriction. Now, that's a pretty broad work restriction. How often might you need breaks during the day? This person needs to lie down 3 hours every day in a darkened room. Every day? Let's take a look at those chart notes. Are they showing up at the doctor regularly? Do the pain complaints made to the doctor suggest that that statement is true, or is the doctor just trying to fudge it a little bit and help you along the way? These are questions that judges ask. And the better your medical record, the more robust your medical record, and the more the medical record focuses on your functional limitations, the better are your chances of approval. All that makes sense? Okay. You know, let's see. We have 15 minutes. Oh, by the way, The doctor mentioned there would be a question answer session later this afternoon. I will hang around for that. So, if we don't, yes. What's your question?
So my question is, if I get treatments that require bed rest for
Yes.
3 to 4 days afterwards, once every 5 to 6 weeks, like you said, if someone's going to miss it because of symptoms, does it also count for treatment and
Sure.
recovery time? So
Absolutely.
okay, so a functional expert would hear, okay, well, she has treatment every 5 to 6 weeks where she's on bed rest. And
Yeah, the question is-
5 days at least just from the planned treatment, not alone from symptoms and other things.
Well, the question would be, where does the information come from? If the doctor's report says, we're going to institute this series of treatments, or we are or she is and she is treated on Wednesdays, and then Thursday and Friday she has to be home at bed, in bed, no problem. Duration requirement, 12 months, and well, let me divert and tell you a little story. Some of you may know somebody who has problems like this. Breast cancer. 15 years ago, not nearly as treatable as it is today. And I've seen a number of cases in which a woman, or in rare cases a man with breast cancer, gets treatment, chemotherapy, reconstructive surgery, radiation, whatever it is, physical therapy, and after 10 or 11 months, the CT scans are showing no cancer in the body, and that person maybe doesn't meet the duration requirement. But almost everybody I know who's gone through that kind of intensive and invasive treatment has a pretty big emotional footprint left in their lives. And, there's varying thoughts about depression in a legal arena. A lot of people think it's just something people make up in order to try and get across the finish line. I don't. I've had clients who've committed suicide if they got turned down. And it's a problem that I take seriously. And I think the courts should take more seriously. But where there's an emotional footprint, not just a cognitive one, but an emotional one, that counts. And it's important that you get treatment for it. You can't just walk in and say to the judge, I'm depressed. He's going to want to know how that depression functionally interferes with what you can do. You can tell him, well, I can't get out of bed in the morning. What kind of functional impairment is that? What does your doctor say? That's what the judge wants to know. And you might know, most of you I assume are patients, that the first thing doctors start asking you about when you go to see them, well, how's this affecting what you do? When you walk into a doctor, they want to know whether you can still drive, can you make meals, conduct regular daily activities. These are things doctors ask to measure the severity of a problem. Judges ask it too. Okay? Yes?
One question I have is, you mentioned some ways to go on the path of applying for these benefits.
Yeah.
What role does an attorney play in the beginning of that path, or does one approach an attorney after that's all been rejected?
There's two answers to that question. One is get the attorney involved immediately, and the other one is go ahead and apply and see the attorney only if you get turned down. In other words, it really does depend on the circumstances. The best thing an attorney can do for you at the initial application step is make sure of two things. Number one, that you identify all of the relevant medical treatment and where to point Social Security to it. But number two, how to describe your work. One of the forms you fill out in an initial application is a work history report. And on that report, you're asked to describe the jobs you did. And sick people who can't work, in my opinion, most of them wish they could. And they look at the days when they could work as the golden days. And so you ask them, well, tell me about what you did in your work. And they start talking like they were God's gift to the employer. And it's perfectly understandable why they would do that. I remember I had a client one time told me when I asked her, she worked for Boeing, what'd you do for a living? What did you do for Boeing? She said, we made the space shuttle. She was proud of her work. Turns out what she did was glue tiles on the space shuttle. And you know, that means you got to climb ladders and use noxious chemicals and all sorts of other stuff that helped our case. But the point is, I've seen work history reports in which the individual actually wrote sideways up the margin to talk about everything they did and how important it was to their employer. Well, 2.5 years later, they're in a hearing room. They've forgotten they even filled that thing out. And the judge asks them about their past work, and by this time they've seen a lawyer who said, emphasize the physical demands. Oh, I had to climb ladders and da-da-da. Okay, the judge looks at that tarantula spider vocational witness over in the corner of the room and says, Mr. Vocational Expert, can you tell me, did this job provide any skills that would transfer to any other work besides the past work of the claimant? Remember, I told you don't have to be completely bedridden. That if you're over 50 and you can't do your past work and you're limited to sedentary or sit-down, unskilled work, you get disability. So there's going to be an issue at the hearing of transferability of skills from past work. And the average person who doesn't speak to somebody who knows about the process generally goes a little crazy talking about their past work and talking about things they shouldn't talk about, or at least not until they're asked. Okay? So in those two particular areas, an attorney can be helpful, but really in the initial application stage, the attorney doesn't get to intervene much. You don't get to make arguments to some decision maker and so forth. So what's the good advice? Well, the good advice is try it on your own. See if you get paid. If you do, you don't owe anybody an attorney fee. If you don't, you can come back and talk to me. Now, that works for most people, I imagine, but I do also know that 2 out of 3 denial rate, and of the people who get denied, 44% do not appeal. They just say, well, I guess I'm not disabled. Throw it over their shoulder and forget the whole thing. Or they get so discouraged. I've been off work 6 months and they don't care about me and they don't believe me and the hell with it. Those factors cause people not to appeal. So really you got to assess the individual, the nature of their past work, and a lot of other things to determine whether they ought to be using a representative or an attorney. And those are the factors to consider. Yes?
Okay, 2 quick questions. Can you apply for a disability if you're on unemployment?
You can. You can.
There's no conflict of...
None. Well, there's no legal conflict. Nobody's going to haul you off to jail for collecting benefits from both. But you could find yourself at a hearing. The judge says, why'd you stop work? Well, they discharged me. Oh. Did you go on unemployment? Yes, I did for about a year. Don't you have to fill out forms every couple of weeks that say you're ready, willing, and able to work? Well, yeah. But I needed money. I had to do something. Oh, so it's okay to lie to the state of California and you're telling the truth to Social Security. Or could it be the other way around? you were telling the truth to the state of California, and you're kind of fudging it for Social Security. So unemployment can create credibility issues at a hearing. Now, the Commissioner of Social Security says unemployment and the receipt of Social Security disability benefits are not incompatible situations. And the Commissioner advises adjudicators to look at the facts of the situation and see what's going on. But that means they usually will. But is there anything illegal about it? No, nothing at all. Side note, workers' comp is different. The receipt of workers' compensation benefits can affect your entitlement to disability benefits. Not often, and maybe not completely, but it can have an effect, so can the receipt of state disability benefits. But an inheritance of $1 billion or a private retirement pension from your employer, that's fine.
You mentioned,
Ladies first.
you mentioned that there's no income, like cap on SSDI, but there is on SSI.
Right.
So if there's no income cap on SSDI, what's the average, or how do they determine like what your monthly benefit amount is?
Your monthly benefit is approximately equal to your full retirement benefit at full retirement age. I think the average retirement benefit, I just heard on the radio the other day, is about $2,500 a month. Not a lot of money. If you have a minor child living at home, there's a 50% bump that you get from disability insurance benefits only, okay, not from SSI or anything like that. All right? Yes?
My one other question was, we were kind of in denial. My wife was the one having all these issues, and the denial was, boy, we hope this gets better. It's been 5 years.
Uh-huh.
Waiting this long to start this process, is that something that's looked down upon in this process? Does that make us less likely because we didn't jump in early?
No, I don't think so. I hear a lot of people say, well, I hoped I could go back to work. You do have an insured status problem. Remember, for disability insurance benefits, you have to have worked 5 of the 10 years prior to the start date of disability. Otherwise, you're not insured. So even if you're disabled, you don't get paid anything. But as long as you're insured at the onset of disability, even if 10 years later you're applying and you're no longer insured, you can still be paid for that disability as long as you show the onset date started while you were insured.
The onset date, like 10-year window? The onset was within
The start date of disability, you look back 10 years, and the person will be insured if 5 of those 10 years the person worked. Okay? Yes, way in the back. Okay, yes, how are you?
So my question is about functional capacity evaluations.
Yeah.
How often are those prescribed? And as a physical therapist who has done them, I know how extensive and difficult they are, and they can exacerbate our condition. So that's where my concern lies, and you don't want to decline that assessment, but how often are those?
Well, I can tell you as a lawyer that if I'm in a hearing, what I'm trying to prove is that my client has a very limited functional capacity. Now, you can't hold an x-ray up to the light and say, how much can this person lift based on this x-ray? It's always a judgment call. And judgments are pretty imprecise. If there's a functional capacity evaluation in the file, it's a strong piece of evidence. But it could be a strong piece of evidence both ways. What if it says you can lift 50 pounds and stand and walk 6 hours out of 8? There goes your case. But it's something more than just a generalized, oh, here's what I think. And it's a good piece of evidence. So If it can be done, it should be done. Yes.
Okay, so you have a job, you have a condition
Mhm.
that requires you to be sitting.
Okay.
It's great if you can lean back,
Okay.
and it's even greater if you could go lie flat every few hours and get your energy back, right?
Mhm.
So you have a job for 10 years that's allowed you to do that. Work out of home, sit back, you're on salary, you pay, but job goes out. So would disability look at that and say, well, just find another job like that? Or do they look at that such a restricted?
Sure, I understand.
Go find another one.
I understand.
Good luck here, right?
Look at step 4 here, where the question is, can the individual return to their past vocationally relevant work? Any work that's been done in the 15 years before we decide the case. And the question is, can the person return to that work either as it would normally be done in the economy, or as the person actually did it? So if the person worked at home and worked part-time, even worked laying in bed, but managed to earn at substantial gainful activity presumptive levels, then the question will be, can the person still do that at step 4? If the answer is yes, you get denied, even though there are lots of special circumstances about the way the job was performed.
And so even though the odds of finding another job like that might be 1,000,000 to 1.
Odds of finding a job or employability status. Flowers that bloom in the spring, tra-la. Hey, that's it, folks. Oh, we got 1 minute. Yes, ma'am.
I guess if you apply, if you are awarded a disability, how or does it in any way affect you in the future? Like, what if maybe next year I can work?
Oh, they want you to work. You should know that they allow what they call a trial work period that can be up to 9 months. Not necessarily have to be contiguous, but for 9 months you can go back to work and test out your capability to sustain that. You can get paid $1 million a minute for doing it, and you can still collect Social Security disability benefits. So there are incentive programs to try and get you back there. Okay? All right, folks, let's go eat. Can I turn this off? Do I
They'll
need?
take care of it. yeah.
Oh, okay. All right.
So everybody, lunch is actually outside.